अभी आपको बराह रास्त पीसी होटल लिए चलेंगे, जहां चीफ जस्टिस पाकिस्तान जस्टिस उमर अता बंदयाल खिताब कर रहे हैं।
My brother Judge, Justice Mansoor Ali Shah, learned judges of the Lahore High Court, the judges of the District Judiciary, learned members of the Bar and the National Arbitration Club, distinguished foreign dignitaries, leaders of the industry and commerce, and the regulatory bodies. I am delighted to join you from Islamabad today to celebrate the establishment of the first office of the Chartered Institute of Arbitrators in Pakistan. In this behalf, I welcome Mr. Jonathan Wood and Ms. Catherine Dixon, who, as senior office bearers of the Institute, have graced the occasion to witness their first workplace in Pakistan. Thank you for joining us, sir and madam. Many experts from the arbitration world and the world of ADR have addressed this large audience at your conference today in 5 different panel discussions. They have spoken about the substance, procedure, and benefits of ADR and arbitration in specific types of disputes. I wish to advance today's discussion by expressing the support of the judiciary of Pakistan to the promotion of these 2 forms of dispute resolution in the country. At one level, courts must endeavor to spread awareness amongst the litigant public who enter the court system about the benefits of ADR and arbitration and places that they can find this service. In fact, by issuing procedural guidelines, the 5 high courts of the country can incorporate ADR in the procedural stream leading to judicial determination. The statutory body that can implement this goal is the National Judicial Policy Making Committee. For short, we call it the NJPMC, comprised of the Chief Justices of the High Courts and the Chief Justice of Pakistan for joint decision making on policy issues. In this body, if an enabling decision is taken that would be fruitful because that would provide the legal and administrative framework to all the courts and their subordinate courts for implementing and adopting ADR and arbitration in matters that are otherwise pending before such courts or which enter the judicial system. In this regard, what is necessary, apart from the said decision, is the availability of trained lawyers, or if not lawyers, trained experts who can render the service of ADR as well as arbitration, and trained judges who can deal with the advantages of these 2 forms of dispute resolution and can promote the finalization of disputes without allowing minor technical and procedural objections to prevail. The judiciary, and in that respect, I'm speaking about the administrative structure of the judiciary, can provide the infrastructure and the logistics to the institute for providing the training to lawyers and judges. Justice Mansoor Ali Shah spoke about the mediation centers that were set up during his time when he was serving as Chief Justice of the Lahore High Court. That was a very significant contribution. And I'm very glad to note that the seeds that he had sown are still growing into plants, and probably one day they would become trees. But the fact of the matter is that the bulk of the disputes are still going into litigation. And that is where we have to put a stop. This can only happen if the high courts are committed and follow up on the implementation and the provision of the alternate methods of dispute resolution by providing them with providing the centers as well as the personnel who are necessary for administering such a system and conducting such dispute resolution. I expect that the Chartered Institute would be in a position to help us in this regard and would be able to train personnel within Pakistan, bring in good trainers and give us guidance in this respect so that this practice can be expanded in the districts and particularly the subordinate courts. The second initiative by the judiciary that I can visualize is to inform the federal government about the needs for updating our Arbitration Act of 1940. Justice Mansoor Ali Shah pointed that out, but the fact of the matter is that the flaws or the weaknesses of the present system, which as rightly observed, is not being availed by the litigants today, and they go for ordinary straightforward suits. Those flaws and weaknesses have to be highlighted, and that is a task which the judiciary can perform. We have